Welcome. Thanks for joining. We have question one from February 2011. It's a straight wills question. And let's take a look at the call. Always go to the calls of the questions first. Now you don't, if you're just on the exam, you're not going to know it's wills, but you'll find out very quickly how easy it is to spot what subject it is. Okay, number one, always answer the call of the question. Always go to the call of the question first. It's so easy to decipher things. This is on both MBEs and essays. Okay. So number one, what arguments can A and B reasonably make in objecting to the validity of Tess's 2009 will? So we have to find arguments to shoot down the 2009 will. It's kind of like a backwards way of thinking, but do this. Just let the facts guide you and it'll tell you what looks wrong about that. There's three major issues: formation, revocation, pretermitted children. So keep that in mind. My first guess is, what can they make in objecting to the validity? Well, it wasn't formally executed. That's just the first thing that comes to my mind. We don't know what else is going to be. But so we're arguments, okay, object to validity of 2009 will. And the reason why I like to write out the call of the question is because I know what I'm thinking, I know what to answer. The whole point of having you go to the call of the question first isn't just to blindly read it. It's to understand what the examiners are asking so you know what to focus on. I know that my focus is going to be on the 2009 will because the call of the question, number one, deals exactly with the 2009 will. Number two, does David have any claim? David's claim. All right. So what happened to David? Why is he here? What does he want? Okay. And don't forget, A and B are objecting to it. So A and B object. I assume they're probably going to be on the same team. I'm not quite sure yet. But, well, they do ask about Abel and Bernice. So maybe they have different arguments. We'll have to find out. So if you notice that on this essay, like almost every single wills essay, in fact, if not every single one of them, I have to look, it starts in 2004. Next paragraph, 2009. Then, two paragraphs down, 2010. And then 2011. I mean, you just go in order. It's so easy to organize. Just all this is 1, 2, 3, 4 little mini essays, because each day, 2004, analyze it. 2009, analyze it. 2010, analyze it. 2011, she dies. I mean, you have nothing to analyze there. So it's 3 little mini essays. And if you think 1 hour isn't enough time, try running on a treadmill for an hour or jumping rope for an hour. You'll realize how much time you actually have. Okay, so let's do it in chronological order. Like we always do, take it from the top. 2004, Tess, a widow. Why are they telling us she's a widow? No community property issues. She executed a valid will, leaving her estate to her children, A, B, and C, per stirpes. Now, I remember when this was actually tested in 2011, a lot of people in the exam room freaked out. Per stirpes, what's per stirpes? You don't need to know what it is because they're not asking about it, because that turns out we're not worried about the 2004 will, we're worried about the 2009 will. And in that case, the examiners, they like to do things to get a rise out of you to see if you can maintain your calm under pressure. If you think that's cruel, it's absolutely not. If you don't have the confidence and if you don't have the composure to represent, to be in court in front of a jury, in front of a judge, and answer tough questions and have tough cases, and you're going to freak out because of the word per stirpes, you're not ready to be a lawyer. So the confidence, you have to know, okay, if I don't know it, I'm going to think logically. And guess what? On your bar, it happens all the time. Happened on my bar. It happens on everyone's bar. You're going to get something you don't know. It's okay. Relax. It's going to be something small. I almost guarantee it. So I'm not worried about the per stirpes argument. I know it's very similar to per capita. And I'll just kind of chop the, I'll just do it each one at the degrees of kinship, the levels, if you will. Okay. In 2009, and this is what we're really focused on. So 2004, ballot will. All right, there we go. Ballot, we don't know how it was formed. I'm asking about formation. So 2009, Tess, Abel, and Bernice quarreled, and Tess decided to draft a new will. So if she's deciding to draft a new will, the first issue is going to be, well, was that properly formed? So formation is going to be an argument. Instead of saying, the argument's going to be, well, it wasn't properly formed. She went on to an office supply store, got a pre-printed will form, and filled in the following in her own handwriting. Because it's in her own handwriting, we also have holographic. So there's two types of ways, the formation. So we have formally executed, and that's going to require, we'll get to the plus. Holographic, we have material provisions and signature. And material provisions means the beneficiaries and the name, the names and the gifts. So we just have names and gifts for material provisions. That's all it means. You have to name who's getting your property and what they're actually getting, and then sign it. So I give my little brother Jamie $10,000, sign my name, valid holographic wills. Formal execution, we'll get to that in a second. Because my son Abel and daughter Bernice have been unkind to me, I specifically disinherit it. I give all my property. Should I give and bequeath? Who uses that kind of language? I mean, ask one of your layperson friends, non-attorney friends, someone who didn't go to law school, ask them if they know the difference between bequeath, devise. You're going to get like a blank look on their face. In fact, most people don't even know that. But think about something. Tess, it says the word bequeath. All right. Okay, so here we have, let's see. So what I'm trying to get at is she knows that she's actually creating a will. Bequeath of property university. I'm going to read the rest of 2009 so I can clearly understand what they're asking. Tess signed and dated the form. Great, she dated it. Dates are not necessary, but they're helpful because what that's going to do, it's going to explain, oh, this is in 2009, and it's validly revoking the 2004 will, and it's revoking it by a subsequent instrument. So the next issue here is because this will has now been revoked by subsequent instrument. And there's two ways to revoke with a subsequent instrument, either expressly or impliedly. That means it's inconsistent. I don't think she writes down, and she doesn't because we focus on the language that's in there because that's her will, the one that's indented. She doesn't expressly say, I hereby revoke my 2004 will. But it's implied because it's inconsistent with her 2009 will is inconsistent with the 2004 will, so it's impliedly revoked. Instead of giving it to A, B, and C per stirpes, she's giving it to all the university. So the fact that she's taking all her money and go from here and here, that's implied revocation by subsequent instrument. And yes, it does help if you tell the examiner the difference between express and implied. So we have that. There we go. You might want to stick that in there. Okay, so formation. Tess signed and dated. No one was present when she signed and dated the form, and hence no one signed as a witness to her signature. If you can't see that the examiners are getting at formally executed wills and how it's not formally executed, you're really missing something. Because this is not hard to spot. They're telling you no one witnessed it. And you know there's no witnesses needed for a holographic will, but you need two witnesses being present at the same time when the testator either signs the will, acknowledges the will, or acknowledges her signature on the will. Two people have to be there at the same time. Now, the witnesses don't have to sign in the presence of each other. It's just focus on what the testator is doing, and the testator has to be doing it in the joint presence of two people. Okay, so formally executed. There we go. There's the presence, and it's the presence of two at the same time. Did two people at the same time witness Tess sign? No. Did two people at the same time have Tess acknowledge her will in front of them? No. Was there two people present when Tess acknowledged her signature on the will? No. So that's gonna fall off right there. So we have presence. I just completely went blank right there. They have to sign during her lifetime, which of course nobody signed. They have to understand it's her will, but there's nobody there to understand it. I forget what the signed. Unbelievable how quickly. Okay, so it's clearly not formally executed. Now you have to, you want to move in after 2009 when the legislature implemented the clear and convincing standard. A lot of wills were getting kicked out of the probate court because they weren't technically validly executed because maybe there was only one witness that signed during the testator's lifetime, the other one signed the day after the testator died. Technically, that doesn't meet the formal requirements, but you can turn, anytime you do formal execution, if it's not formally executed, you do the substantial compliance doctrines. Substantial compliance doctrine, also known as the clear and convincing standard. Clear and convincing. If you want to know how clear and convincing works, think about it this. Beyond a reasonable doubt, 90%. Clear and convincing, 75%. Preponderance of the evidence, 51%. And then you get in like the sufficiency to support a finding and the competency to write a will, we're looking at like 5%. It is unbelievably low. The competency to write a will is unbelievably low. Okay, so the proponent and the person who wants the 2009 will, who's the proponent? Who's the one getting the money? University. So the university is going to argue the clear and convincing doctrine until the cows come home. Whether or not they're going to win, probably not, because, I mean, nobody was there. I mean, there was absolutely no witnesses there. There's no, so you can't even use, I don't even think you can even use the substantial compliance doctrine and show clear and convincing without any witnesses is going to be very hard. But the material provisions and the signature is there, so you could say that it was holographically valid. There is an argument here that notice that the language, and this is really kind of a hard one to find, it says, because my son and my daughter Bernice have been unkind, I disinherit them. I give my property to my university. What about Cassie? I mean, what happened to her? I mean, is Tess, and they don't really give you a lot of facts that tell you that she's just an old bat. You have to, does she understand what she's doing here? So does she have the capacity to make a will? So mental capacity, which has been, oddly enough, an examiner's favorite over the last 5 years. Whether that trend is going to continue or not, I'm not sure. But they've had a lot of essays recently. I think 3 of the last 5 have dealt with mental capacity. So kind of be on the lookout of that issue. So mental capacity, and by the way, the burden is extremely low. There's 3 elements, and elements have to be proven. Factors are things you consider. You have to prove 3 things. Number 1, she knew she was making a will. And number 2, that she understood what her assets were, the natural, like she understood the value of her assets. Like, how much money do I have? Remember, I love using this example, you've heard it before, Rain Man, in the, Dustin Hoffman in the movie Rain Man, he had no idea the concept of money. He knew there was money, but he didn't understand the value of money. Rain Man's not competent to make a will. Tess? Yes. So did she understand the value of her estate? And the last thing is, does she know who the natural objects of her bounty are? And that's how you're going to get to the mental capacity thing, because and you have to really, it's a tough one to put together here, because Cassie's missing, and she didn't fight with Cassie. So why isn't Cassie mentioned in 2009? I mean, she just threw out the baby with the bathwater by putting Cassie in that group of bad children that she has? Maybe she was a bad mother. So did she understand what are called the natural objects of her bounty? Did she understand who her family members were? And it's okay to use this language. Knew she was making will, knew the value of her estate and the value of her assets, and understand who her family members are. It's acceptable. I think the actual statutory language is, understand she was making will, knew the nature and extent of her property, which is the value of her estate, and the persons who are the natural objects of her bounty. Nobody speaks like that anymore. Still, still in the code, but just it means who her family members are. Well, did she know she was making a will? First things first. I mean, I give and bequeath all my property. Who uses that term? I specifically disinherit Abel and Bernice. Clearly, she knew she was making a will. Check that one. Did she know the value of her estate? We later find out her estate's worth $1 million. And she gives it all to university, kind of haphazardly, almost to the fact where she doesn't even think about how much money she has. There's an argument there. I'm not saying it's going to win. But did she understand the value of her estate? I mean, it was $1 million. She gave it all to university. She didn't really describe her assets in detail. So there's a little bit of a balancing there that you could come out either way on that issue. Last thing is, did she understand who her family members are? Well, she remembered 2 of her 3 children. I don't know if that's good enough, but usually parents don't forget one of their children, and Cassie's just oddly missing here. So I think your strongest element that you can argue here is she maybe didn't know who Cassie was, and so Cassie could try. Well, Cassie's not even the one objecting to it. A and B are. So A and B are going to be like, look, Cassie didn't even get anything, and there's no reason why. We're the ones who got to fight with her, not her. So A and B are going to argue that she didn't even understand how many children she had. Whether or not that's going to win, I don't care about conclusions, because the last word in every single bar exam essay, except for answer according to God, is discuss. They want you to discuss it, not solve it, not give me the correct answer, not give me the precise language from the statute. Like for those that are trying to memorize law, just understand what it is. I haven't memorized anything, but I can say, just makes sense. Just make it clear and make it clear to yourself. Okay, so knew who her family members are. So there's the discussion there with that. Those are your best arguments that you can make that she didn't validly revoke the 2004 will because it wasn't formally executed, and maybe you could, I don't think you're going to make a good argument for that because it probably was a valid holographic will. You can also say that she lacked the testamentary capacity because she didn't know who her families were. Those are your main arguments you're going to have. In 2010, Cassie, don't forget, Cassie's one of her children. So now we go to 2010. And 2009 was the bulk of the essay, as you can see. Cassie adopted David as her son. Adopted is the same as being a natural child. So the fact that David is adopted from Cassie, David will take just like he was a blood relative, just like he was a natural heir of Cassie. Soon thereafter, Cassie died, survived by David. Well, we have Tess, we have Cassie, and then we have David. That's how the issue goes. Grandmother, mother, son. And the adopted son is the same thing as a son. So here, assuming the 2009 will is invalid, whether it wasn't formally executed, it definitely wasn't formally executed. Maybe she didn't have the mental capacity. Maybe it wasn't a valid holographic will, which I think is a stretch. The gift to Cassie under the 2004 will lapse because Cassie won't be able to take because she's no longer there. So lapse is when the beneficiary predeceases the testator. That means beneficiary dies first. But David, because Cassie is kindred to her mom, obviously they're both blood relatives, anti-lapse will save the gift if there is a gift going to Cassie. So that's what's going on in 2010. And lapse and anti-lapse are so easy to find because a beneficiary dies before the testator. It's that simple. And then if the beneficiary is related blood by blood and leaves issue, which is a child or a grandchild for that matter, but the examiners only go to child level, it's anti-lapse. So there you go. We have lapse and anti-lapse there. Cassie will also try to make one claim, and David's going to make a claim on her behalf. We'll get there in a second. In 2011, Tess died, leaving an estate worth $1 million. So 2011, she's dead. T died, so we're pretty much done. Tess's 2009 will has been offered for probate. Well, think about something. The 2009 will, David's going to try and make a claim that, hey, wait a second. I was born or adopted, he was adopted, after the execution of all of her instruments. I mean, he can make that argument on behalf of himself or on behalf of Cassie. It's going to fail on both regards. But don't forget, the examiners just want you to discuss this. So they want to know, do you understand what's going on? And here's why his argument won't work. First of all, Cassie's going to have a hard time with pretermitted children. So let's look at, we'll put it under David, omitted child. So it's a child, born or adopted, after the execution of all the testator's instruments. We'll just say after 2009. Okay. Unless, number one, it was intentional, and the intention must appear from the face of the will. Left to the other parent, substantially all the estate to the other parent. That would mean if Tess left it to her husband, but she's a widow, so she couldn't leave it to her husband because the husband is actually Cassie's dad. Her husband would be Cassie's dad. Substantially all to the other parent, or outside transfer, which should be trust fund, bank account, stocks, however you have it. Okay, well, think about for Cassie. First of all, was she born or adopted after 2009? No. So there's no, you can't even go down the Cassie alley. So let's talk about David. David was born and adopted after 2009. He was in 2010. But the thing is, this omitted child, it's not omitted issue, it's omitted child. Child means just your child. Issue means, here, watch this. D is issue of T. C is a child and issue. So here's child. Issue means everybody down the line. So a child is just a child, first level. You know, mother to son, mother to daughter. But issue is everybody who comes down. So it's, if you're the great-grandmother, your issue is the grandmother, the mother, the daughter. That's how that works. That's the difference between issue and child. Issue is all the lineal descendants. Child is just child. Because the statute's omitted child, David's going to have a real hard, he's not going to be able to do anything with the statute. So the pre-termitted, omitted child, excuse the same word, omitted, pre-termitted. I say that because I know a lot of people don't get it. It's the same thing, and you can say omitted child, you can say pre-termitted child, it doesn't matter. He won't apply because even though he was adopted afterwards, the fact of the matter is he doesn't qualify. There you go, that was it. So that's about it. So what arguments, again, can Abel and Bernice reasonably make to the objection of the will? And the arguments that they can make is, you know, it wasn't formally executed, it's not a valid holographic will, or she didn't have the mental capacity. I don't know if any of those are actually going to work. And the second thing is, does David have any claim to share to Tess's estate? Well, he is an adopted child, but he's not omitted because he wouldn't qualify, and then Cassie was born before 2009, and she was mentioned in 2004 will. So clearly Tess knew what she was doing, at least on her omitted child. She knew that she had a child. You could say, well, she didn't understand who her family members are, so you could use the argument of mental capacity rather than omitted child. The lapse, anti-lapse would save any gift if there was something going to Cassie. God forbid the 2004 will or the 2009 will is invalid, then Cassie's gift would go to David. So the 1/3 would go to David. And that's pretty much the final disposition. So this wasn't exactly the easiest essay, but it wasn't, again, very difficult. Once you start breaking it down and start seeing what the examiners are doing, it appears, though, that sometimes the omitted child issue can kind of sneak up on you. And just like the mental capacity issue I thought here kind of snuck up on you a little bit. But you have to think of arguments, and this is why it's so important to actually read the facts and put yourself in the examiner's mind. Wait a second. Cassie's mentioned in 2004, but not in 2009. And you have to draw that correlation like, wait a second, what happened to Cassie? How did she not know who her children were? And that should spawn this. Didn't know who her family members were, which would bring up the issue of mental capacity, which was actually a pretty big issue on this essay. Yeah, it was a very big issue on this essay. But anyways, that's a wrap. I mean, that's all we got here for that one. I guess that's a wrap for the 2011 February question 1 wills. Thanks for listening. Take a look at the model answer. If you don't understand anything, it'll explain it in more clear detail. Take care.